start the meeting. As always, I'd like to start this meeting with a moment of silence for quiet reflection. Thank you. Excuse me. I'd like to welcome everybody to the meeting. I'd like to welcome all the honourable members, the officials, and I see that the Secretary of Parliament is on this call. Welcome, Mr. Adams, and the Speaker and his staff is on the call as well. Welcome to them. I'm going to ask the honourable members to introduce themselves for the record. My name is Christopher Fry. I'm the chairperson of this committee, and I'd like to start with member Dugmore.
Sorry, thank you, Chair, and all members and everyone in the meeting. Cameron Dugmore, a member of this committee. Good morning, thanks.
Member Plato.
Yeah, good morning, Chairperson, officials, members. Dan Plato, alternate to this committee. Thank you.
Good morning, Chairperson and colleagues. This is Gillian Bosman. I'm an alternate to this committee, and I'm standing in for Member Bartman this morning.
Thank you very much. I'm just checking to see. We have apologies from members Bartman and Pretorius on the record. Thank you, Madam Procedural Officer. And I don't see any other honourable members on the call. If I now can ask the members of the officials to introduce themselves, starting with Advocate Ace, Yanni Ace. If you could start with your team, please.
Morning, Chairperson, morning, members. It's just Yanni. Leave out the advocate part. Okay. I'm in the Speaker's office. Thank you very much.
Thank you.
Good morning, everyone. I'm Lorica Elliott, and I'm also in the Speaker's office.
Thank you.
Good morning, everyone. Elizabeth Klute in the Speaker's office.
Thank you. Advocate Leroux.
Good morning, Chairperson. Good morning, everybody else. My name is Andre Leroux. I'm the Senior Legal Advisor.
Morning, Chairperson. Morning, honourable members and colleagues. It's Romeo Adams, Secretary to the Western Cape Provincial Parliament. Chairperson, maybe just my office has advised that I'm actually toggling between two meetings, this meeting and the meeting of the Audit Committee on the institution's audit reports. So at some stage, I might have to drop out and then drop in again later. Thank you, Chair.
That's no problem. Thank you. Are there any other officials that are present that would like to introduce themselves?
Morning, Chair. My name is Temba Keswa, PEO. Thank you.
Thank you, Temba.
Good morning, Chair. My name is Carolyn Prakasa, People Management.
Thank you.
Morning,
Good morning,
Chair. Morning, assessment. Sorry. Okay.
So I heard a lady's voice there.
Okay.
Good morning, Chairperson. I'm Saskia in the Secretary's office.
Thank you. And then Mr. Sassman, good to have you back after your bout of illness, sir.
Thank you. Mario Sassman, Manager Committee Support. Thank you.
Thank you.
Morning, Johan Vermeulen, also in the committee section. Thank you.
Thank you. And I see the speaker is online. Mr. Speaker.
Good morning, Chair. My apologies for joining late. I struggled with connectivity.
That's quite in order. Before we go any further, let me just outline the rules of engagement for these meetings. Let me ask all members of the meeting to be muted at the beginning. the honourable members, if you could flag points of order in the chat function of MS Teams. We will be monitoring that function. All video and audio must be switched off to improve the quality of the connection. If an official is speaking, you may put on your mic and video. Also, please switch off your mic once you have finished speaking. I will now ask to move to the next item of the agenda, which is a briefing by the Parliament on the amendment bill, bill number 7 of 2023, the determination of the number of members. Mr. Speaker, I know Mr. Adams already outlined that he's toggling between two meetings. So if I can ask you, Mr. Speaker, to have if you have any opening remarks before we go to the presentation.
Thank you very much, Chair. Good morning, colleagues. Now, Chair, I think let's go straight to the presentation, and then I'll answer if there's any questions at the end of the presentation. Thanks, Chair.
That's quite in order. I understand, Advocate Leroux, you will make your presentation to the committee right now. Advocate Leroux?
Yes, good morning, Chairperson. Yes, let me just flight the presentation for everybody. Chairperson, is the presentation visible?
Yes, it is. It's visible on my side. You can just make it as a slideshow so it can be fully a bit bigger. There we go.
There we go. Chairperson, as you know, I've been asked to brief the committee on the Constitution of the Western Cape Amendment Bill, determination of number of members. As introduced, the bill was introduced on the 10th of July of this year, and then it was referred to this committee. Chairperson, just maybe some introductory notes on this presentation. When I prepared the presentation, I had in mind that we will, in all likelihood, also go out to public hearings. So I made an effort to include everything in the slide that I thought could, is likely to crop up in public involvement as well. So to include as many items on the slide as possible. Having said that, I appreciate that some or all of the members of the committee may be familiar with some of the matters covered in this slide. And I don't want to necessarily spend time. I don't think anybody wants me to spend time on information that everybody's familiar with. I mentioned that specifically, Chairperson, and I'll ask for the committee's guidance here. On the first 5 slides, we deal with the whole question of why determining the number of seats, or let me rather say the mechanism of determining the number of seats in the Western Cape. Why that is legally, that is a different procedure than the procedure followed by the other provincial legislatures. And then there's quite a lot of particulars on that. I think that some or all of the members have received that briefing at some point in the past. So I'm perfectly willing to go, of course, to go through the slides again. I just want to get an indication from the committee whether the members would like me to go through this, or whether there are maybe members that are not familiar with these legal requirements, or whether I should just proceed to the other slides. Chairperson.
Advocate, we do have some alternate members on the call, because we have to apologies. I would like to ask the alternate members if they are okay. Would they like the background on the legal requirements, or are we able to go through with them? Members Bosman and Plato, are you okay if we go through the legal requirements, or would you like us to go through the legal requirements again?
No, Chair, I think you may proceed. I'm quite familiar with the process and the issues. Thank you.
Same on my side, Chair.
Thank you very much. Okay, Advocate Leroux, you may go through the rest of the presentation then. Thank you.
Thank you, Chairperson. So I'll give a 20-second just summary on that. So I think we are all familiar that changing the number of seats in the legislature requires an amendment of the provincial constitution, and then there was some case law on that in the past. Chairperson, then I'm going to move on. The next 5 slides deals with the background and the development of the bill, which I think will in all likelihood be important to the committee in its processes going forward. So on the 28th of March of this year, the House resolved for the provincial constitution to be amended to add a formula for the determination of seats, an upper limit for the number of seats, to provide a mechanism for determining the number of seats, and to amend Section 13 to achieve all of that. The House also resolved for the Speaker to be the member in charge of the proposed constitutional amendment. It was the purpose of these resolutions, and this was by an ad hoc committee that was established to consider the issue of increasing the number of members of the legislature. That committee found that the number of seats allocated to the legislature is no longer adequate, and that the current number of seats is not sufficient to represent the people of the Western Cape optimally as accountability is compromised. So that was the findings of that parliamentary committee. On the 6th of April 2023, a draft, at the time it was called Constitution of the Western Cape First Amendment Bill, was submitted to the Secretary. Obviously, it was the objective of that bill to result in amendment of Section 13 of the Provincial Constitution. And then that proposal also included a project outline and a detailed narrative in respect of the steps that needs to be taken to finalize the constitutional amendment in time for the next general election. Later on, Chairperson, in the presentation, I'll just pause at the project outline and just reflect on where we are and what what the time constraints are that we are looking at. Between the 21st of April of this year and the 11th of May of this year, the parliamentary administration consulted with various key stakeholders, including the DG of the province, Provincial Treasury, the Provincial Department of Infrastructure, the Provincial Department of Police Oversight and Community Safety, and also with the Electoral Commission. I think the focus was there really to just engage those very key stakeholders that almost certainly have some or other substantial interest in the draft legislation. The key stakeholders at this point made verbal or written submissions. In large part, those submissions simply took note of the bill without making material inputs. But also, I think at that point, it was also clear that there will be many further opportunities for comment on the bill. As proposed in that project outline, the bill had to be published in accordance with Section 10 of the Provincial Constitution. So there are certain requirements in Section 10 in respect of a constitutional amendment bill that had to be complied with. I'll reflect on that also in a further slide. And then, of course, there are also some certain specific standing rules of the legislature that apply specifically to constitutional amendment bills that also had to be complied with. So to give effect to Section 10 of the Provincial Constitution, on the 18th of May, the bill was submitted by registered post to all municipalities in the Western Cape. On the 19th of May, the bill was published in the Provincial Gazette. It was also published in the Burger and the Argus. And on the 25th of May, it was published in Vulcani. And the bill was also published on the website and on social media. And the closing date for public comment was the 27th of June of this year. And the Provincial Constitution in that respect provides that the bill must be published at least 30 days before introduction. So that was how that date of the 27th of June was selected. Out of this process, one comment was received to the effect that the formula should be one in 140,000, one member for every 140,000 residents of the province, rather than the proposed 1 in 100,000. I will also mention that the submitter of this comment also asked for particulars on the fund, and that we indicated at the time that those implications are still being considered. and that those implications will be made publicly available at a future point. Since then, I mean, after the 27th of June, following the process provided for in Section 10 of the Provincial Constitution, there were certain further comments received. The Office of the Premier made comments. I think we received those on the 6th of July. Comments were received by the Commission for Gender Equality, comments by the Provincial Treasury, and then there were also various inputs from the parliamentary administration itself, from the Chief Financial Officer specifically on the financial implications, and from the Language Services Unit that made quite a lot of useful contributions on the draft itself and the language aspects of that. Chairperson, all the comments received, which in this case is one, in terms of the process in Section 10 of the Provincial Constitution, had to be included with the bill on introduction. So I would assume that information would be with the committee. And then I'm not sure whether these comments have been provided to the committee yet, but I'm sure that it will eventually be included in the committee documents and the matrix that we usually compile. Chairperson, should I pause there for questions before I move on to the next part of the presentation?
No, I think you can go forward with the presentation, Mr. Advocate Larue, and then we'll take questions at the end.
Thank you, Chairperson. Chairperson, then I thought it would be a good idea to just point out how the bill as introduced, which is the bill that is now with the committee, how that bill differs from the bill as it was published in accordance with Section 10. I'm not going to spend time on all the minor changes, the more technical changes, but there were a few changes that are maybe of more interest. So on the title, yes, the word draft was removed because it's no longer a draft bill, it's now a bill as introduced. The expression determination of number of members was added to the title of the bill. The bill was initially called the Constitution of the Western Cape First Amendment Bill. We weren't quite sure what title to give it. Of course, the title can still change. And the concern there was that at present there is a Constitution of the Western Cape First Amendment Bill that has been introduced. And there was a concern that we don't want to introduce two bills with the same title, and that may, of course, also create confusion. So the title was changed to the Constitution of the Western Cape Amendment Bill, and then in brackets, determination of number of members. So that was added to avoid confusion. The long title was added. I think those are just mostly just kind of traditional technical amendments, just to align the long title with the form that we usually use in the province. There was a minor amendment to the short title. The word bill was replaced with act. And then there were also on the proposed amendments to Section 13 of the Provincial Constitution, there was a proposal by Language Services that where we use the word seat, that should be replaced with the word member. And we agreed with that proposal. The Constitution and the Constitution of the Western Cape refers to the number of members rather than the number of seats. So technically, that's maybe preferable. And the word seat was initially used because that was the word that's used in the Electoral Act. But it seemed that we would rather use the terminology used in the Constitution and the Provincial Constitution. I think this was an important amendment. The short title and commencement was further amended to provide for two distinct respects in which the Act will come into effect. Section 13.2, it is proposed in the bill of the Constitution of the Western Cape must come into effect before Section 13, subsection 1. To empower the legislature to determine the number of members before the general election. And then Section 13 sub 1 will will only come into effect after termination of term of this legislature. I think the reasoning there is probably fairly self-evident, but one wants to be cautious to pass the amendment bill. The Premier assents to the bill after the Constitutional Court certified it, and then technically we should have a certain number of members that we do not yet have, and that might create all kinds of questions as to whether the House is properly constituted, etc., etc. So practically, Section 13, subsection 1 will only come into effect once the term of this Parliament comes to an end. And then also a minor amendment, obviously the memorandum on the objects of the bill as published in accordance with Section 10. After that process, that the memorandum changed, and that is reflected in the memorandum on the objects of the bill as it has been introduced at this point. Chairperson, on the timelines, I'm not going to spend much time on what has already been done, and I think I commented on that already. Closing date for comments was the 27th of June. The comments clearly obviously had to be considered, and we had to apply our minds as to whether the bill needs to be amended in any ways before introduction. As clearly, I've already indicated there were some amendments to the bill before introduction, and then the bill was introduced on the 10th of July 2023. Chairperson, this is the timelines that has been proposed from when the House resolved for Section 13 of the Provincial Constitution to be amended. And it was a flexible document in the sense that clearly, there are always sort of unforeseen things that happen. But this is the proposal from the administration that in order to achieve the objectives of changing the number of members, certain things need to happen in certain timelines. At this point in time, the next step would be, and which is obviously where we are now, the legislative process culminating in adoption in the House. The proposed timeline there was, or deadline was by the 17th of August 2023. Initially, that would have been a period of 6 weeks from when the bill was introduced. I'm going to go through the timelines because that will also explain as we go through it further on why there's particular constraints in terms of what we must do and when we must do it. What makes the next point 8, what makes the constitutional amendment bill different, of course, is that it has to be certified by the Constitutional Court. So once the House passes the bill, the Speaker must refer the bill to the Constitutional Court for certification. So application will have to be made to the Constitutional Court for certification. The rules of the Constitutional Court provides for that process, but only there's not a lot of particulars there. So effectively, once the Constitutional Court receives the papers, the Chief Justice will issue directives as to when, what kind of notice must be given to other interested parties, when those other interested parties must file their papers, where they must file heads of argument, etc., all those things. There was correspondence between the Office of the Speaker and the Office of the Chief Justice, where I would say the intention was to alert the Constitutional Court to the fact that this is something that the legislature is working towards, and to get a sense that way from the Constitutional Court regarding timelines, because that's clearly central to our planning, as this document reflects. The response from the Constitutional Court was briefly to the effect that the court will only consider or engage on the issue once papers have been filed. So that's not practically very helpful in the sense that we can only gauge the Constitutional Court's timelines and expectations once the papers are filed, and that process can only be completed after there is actually a bill. that can be referred. If the legislative process comes to an end on the 17th of August or thereabouts, the planning is a 2-week period for the court papers to be finalized. Obviously, those conversations will have to happen more than 2 weeks before finalization of the court papers. But the idea would be then by the end of August for those papers to be filed with the Constitutional Court so that we can get an indication from the Constitutional Court on their timelines. And obviously, we will have to argue in our papers what our views are regarding urgency and ask the court to entertain the matter in a certain time frame. After certification by the Constitutional Court, so the period allowed there is a period of 12 weeks for the certification process in the Constitutional Court. Maybe I should add that we cannot know yet whether there will be opposition to certification. There may be amicus curiae, other people with an interest in the bill that may oppose the certification. And obviously, once the matter becomes opposed, it becomes a lot more cumbersome, or a lot more complicated. We provide there for 12 weeks for the Constitutional Court certification by the 23rd of November of this year. Then there's a period of 1 week for the Premier to assent to the bill and publication. In this case, the Premier has to assent to the bill if the Constitutional Court certifies it. So it's not really discretion. Then there's a period of 2 weeks. Obviously, once the provincial constitution has been amended, there must still be a process where the determination of the number of seats is actually effectively made. And I will refer to that a bit later on in the presentation as well, what the proposal is there. But in short, there will probably be a committee that will meet and that will have to look at the evidence regarding how many residents there are in the province, et cetera, and make that recommendation. And then once that determination has been made to correspond with the Electoral Commission. Chairperson, on the Electoral Commission, in the initial stakeholder engagements that I referred to earlier, the Electoral Commission indicated they have their own process for determining the number of seats of the other provincial legislatures in accordance with the Electoral Act. And they indicated that for purposes of their processes in preparation for the next election in 2024, they would want an indication from this legislature as to what the number of members in this legislature would be. And I think that ultimately set the ultimate deadline, to put it that way, for concluding this process. Was that request or requirement, as it may be, by the Electoral Commission, that they need to have clarity on the number of members in this legislature by the end of this year. Chairperson, then just briefly on the bill as introduced and what it contains. Fortunately, it's a very short bill. So there's only 2 slides on that. So it's the Constitution of the Western Cape Amendment Bill, determination of number of members, to amend the Constitution of the Western Cape 1997 so as to provide for the number of members of the legislature and to provide for matters connected therewith. Section 13, I would say, is at the heart of the amendment. I'm not going to read all the underlinings and all the deletions and additions, but the effect would be for Section 13 of the Provincial Constitution to read number of members of the Provincial Parliament. The Provincial Parliament consists of 1 member for every 100,000 of the population whose ordinary place of residence is within the province, but may not exceed 80 members. And I think the members will see that also aligns with what the House resolved in March, what we should be looking at. And then sub 2, to read the number of members of the Provincial Parliament must be determined in the manner provided for in its rules and orders. So that's the proposed amendment to Section 13. And then the proposed clause 2 of the bill would refer to the short title and commencement, what the act is called. And then it provides that in respect of section 13, subsection 1 of the Constitution of the Western Cape, that section will take effect on the day before the first day of polling for the next provincial parliament. And section 13, sub 2 of the Constitution takes effect on publication in the Government Gazette. Chairperson, just to maybe also mention, and the wording here, specifically the wording here in the proposed section 13, sub 1 is very similar to the wording used in the Electoral Act. I think if the members look at that, except of course, as I mentioned before, that they refer to the word seats, where we made the decision to refer to use the word members. Chairperson, I'll just mention these slides quickly. So this is reflected in the memorandum of the objects of the bill. Quite simply, clause 1 substitutes section 13 of the Provincial Constitution to provide for a formula for the determination of the number of members, to provide for an upper limit for the number of members, and to provide for a mechanism to determine the number of members of the Provincial Parliament. Clause 2, just mention also here section 108 sub 4 of the National Constitution. So clause 2 provides for the short title and for commencement. Commencement of section 13 subsection 1 is linked to section 108 sub 4 of the Constitution. What the Constitution says there is that a provincial legislature remains competent to function from the time it is dissolved or its term expires until the day before the first day of polling for the next legislature. So the members will also see that that is the wording used in the proposed amendment, the first day of polling for the next provincial election, to make sure that there's no confusion as to at what point in time the legislature is, what the number of members are in the legislature at a particular time. So obviously the intention is that after the election, the new number of members will become operational. And then section 13 sub 2 of the Provincial Constitution to be amended or to become effective, as I've mentioned before. That determination of the number needs to be made and needs to be communicated to the Electoral Commission in a certain time frame. Some of this, Chairperson, I've already mentioned, so I'm not going to read everything again, but this is specifically consultation as referred to in the memorandum on the objects of the bill. It's mentioned in the memorandum that the Parliament consulted internally by establishing an ad hoc committee titled Ad hoc Committee Seats, so that was an internal parliamentary process. Also through this committee, and this committee made recommendations to the House regarding review of the number of members of the Provincial Parliament. And as I've mentioned already, part of the consultation process was also the consultations with these various bodies, the DG, Provincial Treasury, etc. That preceded the publication in accordance with Section 10 of the Provincial Constitution. After that process, in accordance with Section 10, we complied with that. So the bill was, as I've already mentioned, was published in the Provincial Gazette, various newspapers, on the website and on social media. The closing date was the 27th of June, and one member of the public commented. And then obviously after that process, we could look at introduction of the bill. Pardon. Chairperson, on the financial implications in the memorandum, what the memorandum provides for, it indicates the Provincial Parliament will incur costs for legal representation in the Constitutional Court in respect of certification. The bill will have financial implications in respect of the remuneration of members, accommodation for members, allowances for political parties, enabling allowances for members, support by the parliamentary administration, and operational expenditure. and the provincial parliament will be responsible to carry the costs of implementing the legislation. All of these items are, of course, mentioned in the memorandum because that is what the standing rules requires of a memorandum on the objects of the bill. Chairperson, so as far as the memorandum is concerned, this is what is provided for in the memorandum, but there are no figures or numbers in the memorandum on the objects of the bill. The next, you can just see, yes, the next 3 slides, these were inputs received from the Chief Financial Officer of the administration. And so the next 3 slides looks at, Chairperson, the projected financial implications. Obviously, my knowledge of the details of all of that and how exactly that's been compiled won't be as or nearly as comprehensive as the colleagues in the financial space. Chairperson, I think what would make sense is to start with an additional 6 members, to start with the smaller increases and then move to the bigger increases. But the projections were made on what would be the projected financial implications if there was 1 member for every 150,000 residents, or 140,000, or 130,000, or 120,000, or 110,000, or 100,000. So there are 6 projections. The first one would be for 1 in 150,000. Then that would result in an addition of 6 additional members. And then the committee can for itself see the total projected financial implication for that. I'm going to scroll back to this slide later. So for if we use the formula 1 in 140,000, that would result in 9 additional members. And then the projected expenditure would be as follows. 1 in 130,000 residents would result in an additional 13 members, and the projected expenditure would be as follows. 1 in 120,000, an additional 18 members, and then the projected expenditure over the MTLEF. 1 in 110,000 would be an additional 23 members, and then that would be the projected expenditures. And then if I scroll back to the first slide, if it was 1 in 100,000, 1 member for every 100,000 residents, that would result in an additional 30 members, and then these would be the projected cost of that. Of course, at this point in time, the draft as it's looking at present provides for this option. But also, of course, that may change depending on what the committee in the House ultimately decides. Chairperson, I'm going to move on there from these 3 slides. And then the last slide, as I mentioned earlier, so it's proposed for section 13, subsection 1 of the provincial constitution to provide as follows. One member for every 100,000 of the population. And what's important here, and I thought this needs to be mentioned because certainly there will be questions on this as well, is the proposed section 13 sub 2 of the provincial constitution, which provides the number of seats of the provincial parliament must be determined in the manner provided for in its rules and orders. And I wanted to point out that there has been proposals, and I think those proposals are with the subcommittee on rules review, to make provision for this process in the standing rules. At this point in time, the proposal is that there be a new rule 210 with renumbering in the standing rules, and it will provide that subject to the provisions of section 13 of the provincial constitution, so subject to what has been constitutionally determined in subsection 1, and by no later than 1 year before an election for the provincial parliament, the number of seats of the provincial parliament must be determined by resolution of the House. This wording here in point number 2 is almost identical to the wording that they also use in the Electoral Act. The determination referred to in sub-rule 1 must be based on the best available evidence regarding the province's population at the time. And then the determination referred in sub-rule 1 must be communicated to the Electoral Commission. And we will probably have to add that it needs to be published in the Government Gazette as well. So, Chairperson, at this point in time, that's the, say, the working proposal for giving effect to Section 13, sub 2 in the Provincial Constitution once that comes into operation. Chairperson, thank you. That is my presentation.
Thank you very much, Advocate Leroux, and thank you for your very detailed presentation. I will now open the floor for comment or questions. Members, are there any questions to Advocate Leroux for this presentation?
Chair?
Yes, Member Dugmore.
Sorry. No, thank you very much for the presentation. And I think it provides quite a lot of details. I was, looking out for the provision in regard to the rules, and the advocate has clarified that particular suggestion around in addition to the rules. But I'm not sure if I missed this somewhere, but, clearly what I think we're going to need, because I note that only one person so far who's made a submission, has talked about, if I'm not mistaken, sort of a ratio of 1 member to 120,000. And then I think we've seen some of the cost implications of whether you have 9 or, actually go up to the maximum if one estimates that the population is about 7 or 7.2 million, would be sort of roughly another 30 members or so. Now, the issue of investigation that's being done in regard to our chamber, I think it's very clear that, we are nowhere near to be able to, talk of a new venue for the legislature. I know that's been raised over years. So I think one is essentially looking at what we have at the moment. But could I just ask, has there been any work done on exactly how one would accommodate, say, let's work on a maximum of another 30 members, both in the chamber, offices and so on? I know the corridor talks at the moment that, this department could move out and that department could move out, and that could make space for, offices for members. But the physical, architecture of the chamber itself, I think we need to be upfront about this because, from our side, generally the notion of 1 to 100,000 is, I think something that we should go for, given the issues of accountability and other motivations raised. But who is doing work on the actual architecture, the implications both for increasing the physical space or redesigning the chamber, given that it's, I'm sure, affected by legislation regarding heritage sites, etc. Possibly, maybe I've got that wrong. So that's at this point in time the one thing that concerns me, and I hope that once we have clarities on the presentation, we can move very quickly to then looking at when we need to have these public hearings so that we can stick to the timelines proposed. Thank you, Chair.
Thank you, Member Dugmore. Advocate Leroux, can I ask you to stop sharing your screen, please? Thank you very much. Members, are there any other questions before I ask my question? In that case, no. Advocate Leroux, I just want to ask a question about the IEC, the Electoral Commission. They say they want our indication as to what formula we're going to use. Do they not have an idea as to what formula and what basis for their amendments to the increase in seats for the other 8 legislatures. Did they not give an indication of what they are doing on their side? That's my question. Advocate Leroux, over to you.
Chairperson, thank you. I don't know whether the secretary is available. He indicated he's toggling between meetings. I don't think I will respond in detail specifically on Member Dugmore's question, simply because that's not really an area, the issue of the logistics and so on, that I think I can give a lot of guidance on. So I thought maybe if the secretary is available, he could comment on that.
His hand is up, Mr. Adams.
Thank you, Chairperson, and thank you, Speaker and honourable members, and Honourable Dugmore for the question. So with regards to the logistics, we have already started quite soon after the consultations with the provincial government departments that we think might be affected. We have started the operational conversations. So our Directorate Institutional Enablement is engaging the Department of Infrastructure, his counterpart on that side, with regards to not just the chamber, but also other office requirements that might come. It is, however, a bit challenging if we don't know what the exact number is going to be, because that impacts on the options, the scenarios, and then also the permutations. We've also been looking at the chamber specifically, and there are also a few scenarios that could be worked on and planned in terms of that. All of these, Chairperson and honourable members and Speaker, also obviously depends on the mode of operations. We are currently in sittings of the House and work of committees. We are doing the work in a hybrid option, which means it could be in person, it could also be virtual, and that also allows for some permutations that would assist in those type of operations. We are comfortable that in the current seating arrangements in the chamber, we would be able to increase the number of seats minimally, but also if there are other permutations that could be implemented, we could get to quite a substantial number of members being able to be accommodated within the chamber. Thank you, Chairperson.
Thank you very much, Mr. Secretary. Mr. Vermeulen and then Honourable Dugmore. Oh, sorry, we haven't been done. Mr. Vermeulen.
Chairperson, thank you very much. Chairperson, I just want to state that I'm not part of the administration's official team, but I feel that I just want to mention something, if you don't mind, because I was the official who assisted the ad hoc committee who initially looked at the matter of member seats, and there was an issue that just came up. I think Member Dugmore asked something about the formula, and the question from the member of the public of the ratio, rather than use 1 to 100,000, use 1 to 140,000, and then obviously the practical implications from that. So I just want to go to that report, Chairperson, that committee did, and that committee reported to the House. I'll be brief. Let me just find it quickly. And there was a point 7 in that report, Chairperson, that said aspects for possible consideration by the Standing Committee on the Premier and constitutional matters. And the reason why that was not resolutions, but aspects for possible consideration is obviously no committee, not an ad hoc committee, can tell another committee what to do. So the recommendation from the ad hoc committee was there that hold on. Obviously that the constitution be amended, but then the 7.2 says that in considering the variables of the formula, the variable used in section 3 of the Electoral Act 1998, Act 73 of 1998 as amended, be considered as a guideline. And maybe this is where my smarter legal colleague Andre can assist, but I think that, Chairperson, is the formula that the other provinces will use as well, which is the 1 to 100,000. Thank you, Chairperson. That's just what I wanted to mention.
Thank you very much, Mr. Vermeulen. Member Dagmo, your hand was going up and down, I see there. And I noted that you have some previous problems with the raise hand function. But is that a new hand, sir?
Yeah, no, it is a new hand.
Okay.
Thank you. So I just wanted to be sure that, you know, my hand was up and I couldn't quite see whether it was. But my issue is that, you know, arising, Chair, from the answer from the Secretary, I'm very concerned that we go into a process of public hearings without, you know, more work and I'm not sure if there's anything in writing yet in terms of what the Secretary has said, because, you know, there's talk about scenarios and this and that and so on. But, you know, one of the budget items, and I think this is going to be an issue for all of us as well as the public, you know, there's a layout of what it would cost in terms of members and allowances and all of that, given, you know, how many members we might increase by. But I think we need something, you know, at least a presentation which talks about, because obviously we are now going out to consult, and it's clear that, you know, in terms of the actual proposed the proposal that is in the in the bill says 100,000, right? That's what it says, and that means essentially 70 members. So if that is and that has been signed off by the speakers, so obviously it can change, but that clearly puts out a view that we need to be prepared for that number. So what I'm basically asking is that as we prepare for these public hearings, we actually need sort of a component which actually talks about the infrastructure required, you know, and maybe, you know, just creates a scenario of like a 70-member scenario, and then if you say, you know, put a 1 to 150,000, because obviously as much as the Electoral Act, as I understand it, talks about 1 to 100,000. Obviously, it seems to me that the province is really bound by the size, the maximum size, which is 80. It's not bound by a formula, a particular formula. It could come with its own formula. It could say 1 to 120,000 or 1. But given that the bill itself talks about 1 to 100,000, you have to be able to say to the public, in that scenario, we would, in the legislature, you know, add, you know, break out the back section that would create so many more spaces. These are possible options. But I just think we need to be ready for that question in quite a definitive way. So, you know, whether there are just some sketches prepared, or whether, you know, given that we, you know, that some of those committee rooms, you know, whatever. So my request and my proposal is that we need to have, as part of the presentation on the bill itself, we need to have a presentation which looks at the architecture and the physical infrastructure changes needed to accommodate, given, you know, what the Secretary has said about hybrids and different ways of working. I think we need that, and that's my proposal, that we have that before we set out on these public hearings. Thanks. And the costs, obviously the potential costs, sorry, Chair, and the potential costs of that, yeah.
Okay, thank you, Member Dagmo. At this stage, I'd like to ask the Speaker.
Thank you very much, Chair. My apologies again for joining late earlier on.
No problem, sir.
And also, I just want to make an apology for the Deputy Speaker. I didn't have an opportunity to do so earlier. Colleagues, the reality of the matter is that this is the first introduction of the bill, and as the 100,000, just to what Honourable Dagmo has raised, is as the law currently stands, and that's why the introduction happened at 1 to 100,000 members. The committee and the public hearings will then determine what formula, what the actual number of members will be, as determined after public participation, and the committee is within its right through the parliamentary process to make amendments to the bill as introduced. So I don't want us to get bogged down with the idea that that's how it's going to be. That is how the law currently stands, and that's why, I mean, I don't, when I introduce the bill, I do not have the power to just unilaterally decide to change the law as it stands. And I think it's just important that I just put that on the record. Okay, thank you.
Thank you very much, Speaker. If there are no further comments or questions, Advocate Leroux.
Chairperson, I think you had a question that I haven't responded to yet.
Yes, I was going to say that.
Regarding the IEC's processes, what does their processes entail? Chairperson, I'm not going to spend a lot of time on that. I just quickly want to, one of the slides we didn't go through in detail actually speaks to that. Let me see whether I can just flight that. Chairperson, I think the answer to that is that the position of the IEC is very different to the position of this legislature. I think Member Dakmo and the Speaker and Mr. Vermeulen also already referred to that. So the Electoral Act was amended by the Electoral Laws Amendment Act in 2021. And what it provides for at this point in time is the formula for determining the number of members of provincial legislatures. So this is in one of the schedules to the Electoral Act as it is today. And what it says is by taking into account available scientifically based data, etc., the number of seats of a provincial legislature must be determined by awarding 1 seat for every 100,000 of the population. So the IEC has no discretion as to a formula. That has been determined by national legislation. There may not be less than 30 or more than 80 seats. So there's no discretion there, which makes the position different to the position for this legislature. And then it provides that the Commission is responsible for the determination of seats. And this is in this respect where the IEC acknowledges that this legislature will determine its number of seats in terms of the provincial constitution, but and they ask that our numbers be made available to them at the time that they also make this determination. The Commission must give notice in the Gazette, and then of course there must be an opportunity for public inputs, etc., etc. A colleague at one point pointed out to me sort of what would be the point of the public inputs, because the whole issue of the numbers is basically a mathematical question. If there's 14 million people in Gauteng, then the formula is already, there's only one mathematical conclusion, so there's no discretion for the IEC. Chairperson, this is also, I think, initially the ad hoc committee, as Mr. Vermeulen points out, the ad hoc committee suggested that this formula of 1 in 100,000 be used as a guideline. But long story short, this legislature doesn't even have to provide for a formula. Section 13, as it stands at present and as certified by the Constitutional Court, simply states the provincial parliament has 42 members, so it's to the effect period. So that's also an option for the legislature to simply, or for this committee to simply recommend an amendment to that effect, rather than to necessarily decide on a formula. Chairperson, does that address that question?
Yes, that addressed that question very well. Thank you very much for clearing that up for me, Advocate Leroux. Members, are there any other further inputs, comments, or questions?
Chair?
Yes, Member Dagmore?
Sorry, yeah, could I just ask for some clarity then? I mean, all I'm concerned about here is that, we've just had the Electoral Act amendment read out to us and explained again. Now, the last thing we need is some kind of a legal battle or differences. Because, for instance, if the amendment that we are proposing actually said, for instance, one for every 150,000, say we amended that, and now the determination, there's no discretion, as we've just heard. Is it then going to become necessary that that Electoral Act itself needs to be amended? Because actually, you know, it's quite a difficult legal issue, because at the one hand we have a provincial constitution which has been certified, but that 42 which is currently there was clearly based on that formula, because I think at that time we were around 4.2 million or something in the province. So what I'm trying to ask really is that if we did end up coming with a formula which was more than the 100,000, would that have any impact on the IEC's responsibility to determine the seats in the legislature? That's what I want to ask. Would it pose any legal problems for them? Thanks.
Thank you. Advocate Dudu, I'm not sure if you're able to answer that.
Chairperson, I can make a few comments. I think Member Dartmouth's question, obviously I will focus on the legal aspects of it. I think it's fundamentally a policy question, you know, whether from a policy perspective, whether the legislature should follow the kind of the standards or the approach that's being followed nationally. That's the one question, but I will not comment on that. That's for the committee to have those debates on, you know, what is desirable from a policy perspective. I think initially there seems to have been a sense in the ad hoc committee, and that's also reflected in that committee's report, that that should sort of be the point of departure, but it's not fixed. From a legal perspective on Member Dartmouth's question, for example, in 1999, when the IEC determined the number of seats for this province, and so when they did that in 1999, as everybody knows, there was a constitutional court challenge. The IEC suggested that they must determine the number of seats, and the province said, no, we can determine our own seats in terms of our provincial constitution. So that was what that whole question was about. In fact, Member Dartmouth, at the time that determination was made in 1999, the IEC allocated 39 members to this legislature. And the population at the time was, give or take, about 3.9 million. And that's why that determination was made. So they simply did what the Act required them to do, 1 in 100,000. So actually, in 1999 already, with the provincial constitution, actually this province had more members. So it actually had something like one member for, I think, if I remember correctly, every 89,000 residents. So the legal question has been answered in that judgment already. Legally, there's no issue with the WCPP having a different proportion. It could be less than 1 in 100,000. It could be more than 1 in 100,000. And that legally, that question has already been decided. So legally, that is within the remit of this legislature to decide. What would be desirable from a policy perspective is, as I've said already, is a different question. Thank you, Chairperson.
Thank you, Chair.
Advocate Dudu.
Thank you. So as long as we don't go above 80, we're actually fine. We can determine any number up to 80.
That's correct. Advocate Dudu.
Thank you, Chair. Actually, I don't want to. In fact, member van der Westhuizen in the ad hoc committee process asked, well, if he understands the judgment correctly, words to the effect, we can have more than 80 members. I just want to make that point, and I would say that he's correct. So again, even that is a policy question, but technically, Member Dartmouth, legally, it would be possible to exceed 80 members. Thank you.
Thank you very much. At this point, I'd like to thank the speaker and the WCPP for the meeting. It's just Advocate Leroux for the presentation and fielding the questions and comments that the members had. Thank you very much for your time and for your effort and for your input. Your part of the meeting is now done, and you are free to leave the meeting if you so wish. Thank you.
Outcome in relation to the legislature.
Thank you, Chairperson.
It's maintained.
Thank you, Chairperson.
Thank you, Chairperson. Bye-bye.
Thank you.
Thanks, Chair.
Thank you, Speaker. All right, thank you very much, members. We move on with our agenda. It's now point 3 to consider the draft committee program for the amendment bill determination number of members that we just discussed. As per Rule 172, subsection 3B, the Premier declared this bill as urgent. We've now received the briefing and understand the purpose of the bill. Now, we must now regulate our own procedure and timeframes in dealing with the bill, taking the obligation of considering proper public involvement. I'd like to propose that we draft an advert and place it on the different media platforms calling for comment. Due to the urgency and the timelines of this bill, I propose that the committee call for written comment and voice notes to the procedural officer. If anyone shows interest to appear before the committee, we can make the necessary arrangements to receive the oral submission. I have asked Mr. Odendaal from the communications to give us some guidance on the media plan for this bill. Ms. Kamish Ahmad, is Mr. Odendaal in the meeting? Is he able to join us?
Chair, I'm calling him in. I actually told him to be ready at 11, but I'll call him in now.
Okay. Members, while we deliberate, while we wait for Mr. Odendaal, as you can see, the in the timeline, it's a very short timeline for the 17th of August, and I doubt that we'll be able to make that timeline possible. But we must make sure that the public has every opportunity to make input for this bill, because it's a very important bill, but we must also do it in the most innovative way that we possibly can to stick to the timeline as soon as possible. I'm just waiting for Ms. Kamish Ahmad to see if Mr. Odendaal is there. In the meantime, Member Dagmore.
Thanks, Chair. Sorry, I just want to try and understand exactly what you're suggesting. Are you suggesting no public hearings?
No. I'm not suggesting no public hearings. I'm proposing that we before we go on public hearings that we make the comment for the bill public in the best way and the most efficient way we possibly can. And then we decide on the public hearings that will go forward, because I don't want this. I don't want the fact that we never made any public hearings available to go to go to court. Member Bosman.
Chair, I think this process can run concurrently, like it always does with all other public engagement. We can do the public hearings, and we can possibly, my proposal would be that we try to do one in every district. And where not physically possible, we engage the municipalities to perhaps host people so that they can connect virtually. And that the comment period stay open until a specific deadline, which can conclude when the public hearings conclude as well. I think instead of waiting for the comment period to close and then going on public hearings, we can do it both concurrently. Thank you, Chair.
Thank you, Member Bosman. Member Platt, I see you are unmuted.
Yeah, Chairperson. Thank you for the opportunity. It's exactly what I wanted to say, that we do it concurrently. We must also bear in mind we're rushing to the end of the year and time will become more and more precious. We will struggle to find time as the months goes by. So what we can do now concurrently, we will have to do it. And that is part of the normal processes with regard to all other bills and legal issues we need to embark upon. Thank you.
Thank you very much, Member Dugmore.
Yes, Chair. I'd like to support what the other members, Bosman and Plato, members Bosman and Plato are saying. And I think that means that we're going to have to, I presume, get this into programming. And what Member Bosman said, I think we have to do, one in each district, and then obviously including the metro, and so on. So, we just need to put out a timeline or a proposal that we're going to take to the programming committee, because presumably it has to be signed off there, and whether we can do it in a week and a half, do 2 or 3 per week, and then end up on a Friday in the legislature as a venue, etc. But I think we must do it in a sort of a 10-day period and just get it done. Thank you.
Thank you, Member Dugmore. Ms. Ahmed?
Chairperson, I just like to just make a side note that there was your proposal is not necessarily, because I hear members are saying, and members are saying that we want to do it the normal procedure and do it concurrently. So taking into account that, I actually would like to encourage members just to consider what the chairperson has said, in the sense of there is public hearings. I mean, it's not that other committees hasn't done this before. So I know that there is about 4 bills, if I'm speaking under correction, that has called for comment. And extended the time for comment on different public platforms where people has asked, and I think that the reason why the chairperson has proposed going to call for comment, and if people are interested to say that they would like to appear before the committee, then the committee makes themselves available by maybe doing an MS Teams meeting, or actually the committee decides, okay, there's about 20 people that wants to make submission. Let's have a public hearing in a certain district. And what happened is that we've now noticed that in other committees, the committee has saved money as well as time, that instead of going all the way to George and then we're sitting in a public hearing where we have no one. So there has been committees that has adopted this way of doing public hearings. So I just want the committee to know that it's not a practice, that it's taking place at the moment. And I think that putting the advertisements on different platforms has helped getting a lot of comment. And I'm not sure, Johan, if you can just speak about inputs that was done in this way on other committees, because I know it was the Standing Committee on Agriculture and the Standing Committee on Local Government. So the committee must just take into account that it's something that hasn't happened before. Chair, that's just a comment from my side. Thank you.
Thank you very much, Ms. Kamish Ahmed. Mr. Vermeulen?
Yes, Chairperson, Wasima, just lower your hand. Chairperson, thank you very much. Chairperson, this is a practice that has been happening for quite some time now by some committees, whereby the committees first advertise and ask for written inputs, and then in the advertisement state to the members of the public that in the event that you also want to meet with the committee, just indicate that. And Chairperson, from an administrative point of view, and I'm not fighting or arguing or disagreeing with members, I know that the decision is completely with the members, but I'm just explaining from an administrative point of view. The benefit of this is really, Chairperson, that let's forget about the money that you save if you go on public hearings and there's nobody. But if you take decisions that often happens to say, look, we're going to have public hearings in 6 districts, but you don't know if this is the type of bill where you're even going to have one person in that district interested to come and address the committee. And if you had 1 or 2 people, it would have made more sense practically to get them on a virtual platform. So if you also look at the time frame, Chairperson, to say, look, let it run concurrently. What does that mean? Because you have to give enough time and notice to people to know about processes and hearings and so on. So the process is already very short. So I would be just concerned, Chairperson. Obviously, we will do the best that we can, whatever the committee decides, but I would just be concerned to just start working on 6 hearings, and in a very short space of time, you have to be somewhere, and you don't even know if you're going to have people there. And also, in terms of my understanding, I see Advocate Leroux's hand is up, maybe disagrees with me, but in terms of my understanding of the Constitution, Chairperson, it's not public hearings that's highlighted. It's a public participation process. And to give that opportunity to the public to participate. So I think sometimes we highlight the public hearing part, but it's actually the overall public participation process that is important. So that's my part for now. And yeah, thank you, Chair.
Thank you, Mr. Vermeulen. Member Dugmore?
Chair, yeah, no, thanks again for the opportunity and for the input. Look, I think the reality is, we can have a long debate around public participation. And I think, we know from experience that when we seek simply comments, written submissions and so on, you'll get some, but you won't necessarily be able to take the issue, to the ground, where many people who often don't have access to making, email submissions or so on, are not then properly involved. But I do agree that it might, in this instance, because of a lot of reasons, be overkill to try and do 6. So what I want to propose is that we look at 1 hearing which would cover the Southern Cape and the Karoo, another one that would cover, Boland, Overberg and West Coast, which would be a second one, and then 1 in the Metro. So you have 3, plus a public information campaign around what this is about, what are the implications and how people can participate. And then those that would like to actually make a presentation could either be directed to one of these 3 public hearings, or, could actually just do a written submission and also be given the opportunity to go to one of these hearings. So my proposal is to go for 3 public hearings, go for the public information process, and direct those that would like to make physical presentations to come to one of the 3 hearings. That's what I'd like to propose.
Thank you, Member Dugmore. Advocate Leroux?
Thank you, Chairperson. Chairperson, I don't really disagree with anything that was said, and I'm not going to express any views on whether there should be 3 or 5 or 6 public hearings and so on. I mean, that's for the members to decide. I agree with Mr. Vermeulen and Ms. Kamish Ahmad. I just actually wanted to add something. I don't think they are incorrect. I think we've known since the Doctors for Life judgment that it is acceptable for the legislature to kind of put out feelers and get a sense of, what is the public interest in this bill before a committee makes a decision on public hearings. And it may well happen, as it happened in Doctors for Life in a particular bill, there was absolutely no public interest. And then the legislature decided not to do public hearings, and the Constitutional Court did not have an issue with that. And so I don't disagree with any of that. And I don't disagree that that is an option. Chairperson, I just have one particular concern, well, 2. I've commented before that this bill is a bit different in the sense that it has to be certified by the Constitutional Court, and I just want to maybe underline the fact that the Constitutional Court is definitely going to scrutinize our public involvement processes. So ordinarily, one would pass a bill, and if somebody is unhappy with it, then maybe they would challenge it. But in this case, the Constitutional Court will almost certainly have a number of questions on public involvement. In fact, I think the court may be I think the law on changing the number of members is quite clear. I don't think that is likely to be a controversial issue. I think it may even be of greater interest to the Constitutional Court to be satisfied that the public involvement was adequate. So I think that's the one thing I would want to flag, is that I would anticipate that there would be questions about that. And then the other concern for me, Chairperson, is the fact that we haven't communicated the financial implications yet. And I would expect that to be something that would be of material interest, I would imagine, to the public. The bill is very simple. If one just looks at the bill, it's one page. A member of the public looking at it might just, say, okay, this doesn't really look like something that is of interest to me. But once one starts having a conversation about the financial implications, the public may view that differently. So I'm concerned that, for example, we get to the Constitutional Court and we say, well, there was no public interest in the bill, but they ask us, but did the public have an appreciation of the financial implications? I have that concern that one way or the other, the financial implications need to be, let me put it this way. I don't think we can gauge the public interest unless the public is aware of what the financial implications are. And then just a quick last point, Chairperson. I've mentioned the point of the Constitutional Court is likely to focus on the public involvement. I know there are proposed timelines, but I wouldn't want for the committee to feel too constrained, because I think we would be in a better position taking a bit more time and then being able to show the Constitutional Court that public hearings were adequate, rather than limit our own the time that we allow us the legislative process, and then we get to the Con Court, and then ironically that very issue is then the reason why maybe the bill doesn't become certified. Thank you, Chair. I spoke way more than I actually intended to now. Thank you, Chairperson.
Thank you very much for your input, Member Plato.
Yeah, Chairperson, thank you very much. I agree with the two officials, Mr. Vermeulen and Mrs. Kamish, but I want to add to say rather concurrent processes, as I and Member Bosman have indicated, and supported by Member Darkmore. Listening to Advocate Leroux, this issue is a highly politically explosive one as well. And I want to make one or two comments regarding that. For me, this is a little bit different from other bills and other issues. It's amendments to the provincial constitution, and that put the whole issue in a different kind of a framework, as far as I'm concerned, and I see it from a political point of view. I think we must exhaust public involvement more than anything else. Rather more. And as Advocate Leroux have put it, to make it more adequate, and listening to his comments with regarding to the Constitutional Court, what is it they might and would look into, and that sort of thing. That I don't think we want to go to the Court for their approval, and they find one or two mistakes in our chain of timelines and of reaching out to the public and that sort of thing. We need to omit that from the onset. Because this one for me is a little bit different, and looking at Advocate Leroux's points with regard to youth's financial impact. It will have financial impact. It will have impact on our fiscus, and that sort of thing. And how will the public see this change to the Constitution financially, because after all, we're working with public funds. I rather think that we must plug all holes as far as possible, and the sooner we can get this done, the better. And I think that is my clear point of views, that we need to get this out, and we need to get out to the public. I don't think 3 regions is for me more than enough and adequate enough. I think the more, maybe 4, 5 or 6 in different districts, that we do that. It is time consuming. It's a lot of strain. It's a lot of administrative organizational stuff coming into play, but I think we will have to do that to give credence to what we want to achieve. Thank you.
Thank you, Member Plato. Member Bosman.
Thank you, Chairperson. Chair, I think if the deadline is the 17th of August, we don't really have much time to still gauge public interest. I think looking at the appetite for feedback that we got in the first round, the bill didn't get that much feedback, and I suspect that's because very few people probably saw those adverts in the newspapers. And I think if we're going to do meaningful public participation, we need to look at doing proper activations, because I've been at public hearings where there are 4 people, and then I've also been at public hearings where there are 60 people. And I think a lot of that hinges on the type of engagement that happens with audiences beforehand, the type of relationships that we have with NGOs and with the media, as well as with municipalities. And I think it is possible to conduct at least 3 physical public hearings in places of this province where we don't necessarily get the type of media coverage. And I think it would be fair on the process to ensure that the anti-SARAs of the province are also included in this process. And I think we can look at the different structures of how we advertise it, and perhaps instead of just doing a media plan, we can do an actual public engagement plan with the Public Education and Outreach Office to ensure that that happens. I think the easiest thing would be to ask people to whether they want to present to the committee, but in the interest of doing meaningful public engagement and also getting to people that are not necessarily in touch with the systems that we operate within, we should engage in face-to-face public hearings, or if we don't do it face-to-face, if it's an issue around cost, we can engage the municipalities or the Cape Access Centres to ensure that people can go there to connect virtually. Thank you, Chairperson.
Thank you very much, Member Bosman. Member Plato again.
Sorry, I was trying to unmute. No, I think Member Bosman covered me to a large extent. I think the last point I want to make is, regardless if 10 or 100 people arrive at the public hearing, the fact is, what physical attempts have we made as an administration and as a structure to reach out to the public? And I think that for me is important. I also, my last public meetings I had from a social development point of view were some amendment bills and that sort of thing. In Cape Town, we had about 50, 60 people, and we reached out to Lensburg, Beaufort West, and those areas, we reached over 250 people. But I think it's, for me, immaterial. The fact of the matter is we need to prove that we made physical attempts to reach out, and for me that is important. Thank you, Chairperson.
Thank you, Member Plato. So what I'm hearing is that we have a public participation phase of three public engagements, one in the West area, one in the East area, and one in the Metro. And one of these, and then one of these would also be able to have, where we have people accessing the Cape Access Centres and the Tusong Centres for people that are unable to reach us via the hybrid sessions, that we use our PEO department to give us a plan to have, once we have the plan for our public engagements, that we ask the PEO department to execute the plan and to help us advertise a hybrid session, including that makes use of the Cape Access Centres as well as the Tusong Centres, so people can log in also. So 3 public participation events, plus an online one where people can access the Cape Access Centres and Tusong Centres, as well as advertising on social media. That's what I'm hearing. If there's any other views on this, I'm going to ask Mr. Odendaal to give us an outline as to what the the response has been for social media, because I hear Advocate Leroux saying we made adverts for the burger, for Vukani and another newspaper, and we only got one comment from the public. I'm questioning whether, you know, using that advertising channel, whether that is effective. Mr. Odendaal, can you give us some info on the social media aspect and advertising on social media?
Yes, good morning, Chairperson. Good morning, committee. Thank you for the opportunity. I was listening to your reasons and reasoning and how to get as much as possible public participation. And that is also what I would suggest, that we utilize the channels and the mediums, all of it that is to our disposal, to get to the public and get as much as public involvement as possible. So just to sketch out and not in too much detail, is that we would start to put the information on our website, on the homepage. That will always be like the central point of information that will contain the information on the bill. The bill itself you can download there, and also about the public hearings and so on. Then another component that we link to that is then a paid for social media advertising campaign on Facebook. To give you an example, the campaign that we recently had for the advertisements of the position of the Public Service Commissioner, it rendered a result of 280,000 people reached. So, but I think we must just be clear to say that 280,000 people were reached. It doesn't correspond to 280,000 inputs. So it's just 280,000 people saw the advertisement. And that is actually very good if you think that that campaign cost us 5,000 Rand. So yeah, but the question would always be, what about the people that don't have access to the emails and the internet and so on? So the other route that we can also include in this same process is going do media releases to the newspapers, and then also send voice clips with those alerts to the radio stations, so that we potentially can get some free airtime or editorial in the newspaper. Then what we also do is we'll utilize our own social media platforms. That is the ones, our Facebook and Twitter. We currently have almost 7,000 followers on Facebook and 4,000 on Twitter. So in those, we regularly, almost daily, tell people then about this bill. And then if the committee could suggest, maybe Ms. Kamish Ahmad, suggest people that I could link in those messaging, we can even spread our wings a bit further. Then lastly, also to reach people perhaps that don't have access to the internet, so on, is that with the help of our public education colleagues, we can distribute posters with information on how you can submit and even information on the public hearings, and please attend if you want to make an input, and so on. I think I've covered most of what I wanted to say. Thank you. You're welcome to ask questions if there's anything.
Thank you very much, Mr. Odendaal. Members, are there any questions to Mr. Odendaal? Advocate Leroux?
Chair, thank you. I just want to make a comment. The comment being, I mean, yes, the one question is how many people are we reaching out to? And then the other question is what information are we reaching out with? I just want to, I've made the point before, I just want to suggest that financial implications need to be information that is publicly available, because I really think that that is material to the evaluation by the public of the bill. Yes, thank you, Chair.
Just to be clear, Ms. Advocate Leroux, are you talking about the 3 slides towards the end with the breakdown of the 1:100,000 to 1:150,000? Are you talking about that information, sir?
Chair, I don't necessarily mean that we need to share all of those particulars, but I do think that it would be relevant to the public to have an understanding of just what is the ballpark expenditure that implications of the proposed legislation, because that will also just fit into the whole conversation of oversight and accountability and cost benefit, etc. My sense is, there may be disagreement, but if the public doesn't have at least an understanding of, listen here, this legislation, not only what the legislation seeks to achieve, but what the cost is going to be. I think that is a very, very material and highly relevant information that needs to be made available. Otherwise, in my view, we can't. It's one thing to say we reached out to 200,000 people, but then the question becomes, did we reach out with the kind of information that the people needed to really apply their minds to the implications, including the cost implications of the proposed legislation? Thank you, Chair.
Thank you, Advocate Leroux. Member Dagmore? Member Dagmore, you're on mute?
Chair,
okay, there you go.
Yes, thank you. No, Chair, I think what we need to do is, we need to have presentations prepared, presentations prepared which would deal with, the implications of this. And obviously, I mean, one of the big issues that the public will be and should be concerned about are the financial implications. So that's why we should, in the presentation, sort of cover that aspect, and that's why I'm also suggesting that we have a section which deals with the practicalities of increasing the size from an infrastructure point of view and a staff point of view and so on. We need to be upfront about this, but there are other arguments that could be made, around the fact that, since 1994, we have not increased the size of the legislature. This is the norm. This is why we need accountability, etc. So I'm just suggesting that we do have this information available for presentations, but the media campaign, I don't think, there should be sort of a general information that this is happening and a place that people can go to, maybe to access the presentation, the standard presentation, which explains all of this and then advertises the hearing. So I think there needs to be quite a lot of thought put into the way that the public advertising campaign goes. It should be about, this is an important bill, where to access further information, where to go if you want to make a physical submission, etc. But I think both the financial implications as well as the infrastructure implications, we need to be upfront about those in the presentations we make to people. Thanks.
Thank you, Member Dagmore. Mr. Odendaal?
I would like to agree with Member Dagmore. It is we can decide on the way that we want to lead this campaign. In other words, the main messages and so on. And that's why the website is so important, because if people want to know more, they can always go there and we'll have all the information. And perhaps then, if the committee decides, the financial implications stuff can be there, but we don't necessarily have to lead the campaign, the main objective, and so on, in that regard.
Thank you, Mr. Odendaal. Can I recommend to the committee that we adopt a media plan that includes the financial implications of the bill according to what the IEC has placed, and I think we should flight the 1:100,000, the 1:130,000, and the 1:150,000 formula, so we can give a fair financial implication to what the increase of the seats is, because and make it clear that because we have our own constitution, that we are not necessarily bound by the Electoral Act, which is a minimum of 30 and a maximum of 80. But like Member Dagmo rightfully says, that this has been from the current composition of the number of members in the House is from 1994 and needs to be amended. The question is, by how much will the need to be amended? I then also would like to recommend to the committee that we say that we have three or four public engagements that the members of the public are welcome to attend. That we have 3 in-person public engagements, and we have a hybrid one, including the 2 song centers and the Cape Access centers, so that we demonstrate when we file papers to the Constitutional Court, we demonstrate that we have accessed the public as exhaustively as we could have, and that we are satisfied that the public had adequate opportunity and time to make inputs to the bill. Are there any comments to what I've just recommended?
I'm okay with your recommendations, Chairperson.
Thank you, Member Plato.
Sorry, Chair, can I just say that, I don't think this is the place to get into a detailed media strategy, but what I was basically saying is that for further information, people should be directed to a website. I don't think the media campaign should go into all the options. We're just presenting a bill which people must comment on, and roughly saying what it's about. But for people who want more information, they go to a website, I would argue, and then some of those different scenarios can be. So all I'm trying to say is that the campaign should basically explain what's going on here, and then for further information people be directed. But look, the reality is, once this started, there's going to be media inquiries, everyone, so we must just be ready to answer that and have information at one place, which would be a website. I don't know if maybe that's what you also meant, Chair.
Yeah, that's exactly what I meant. Commissioner?
Thank you, Chair. Chair, I think the advertisement will have all my information on there, where it actually says that if you want any further information on the bill will be available on the website. And if you need any further information about the public hearings or anything about the bill, they can contact the PO directly. Chair, just for planning purposes, I just need the committee they have resolved now to have 3 public hearings. I will need the committee to decide. I've heard that there was one in the metro, so this will probably take place in the chamber. Chair, I'd just like to make a suggestion that if you are going to have one in the chamber, we can make it a hybrid meeting, and that is where maybe PEO or Partes can we can put it in the newspaper or in the advertisement, that members of the public are welcome to have access at the access centers and the Tusong centers, because we do have a relationship with the access centers mostly. Gee, I just need the committee to decide what are the 2 areas they are going to. I heard you said the West Coast, but where in the West Coast does the committee want to have this meeting, and where in the other area does the committee need to? Because I actually need to tie down venues and those advertisements now.
Thank you, Mr. Commissioner Ahmed. And I agree. I think the one we can have, the one in the metro, we can have in the chamber as its normal practice. And we can have that one as a hybrid, so people can join online and are able to make submissions either online or in person in the chamber. I would suggest to the committee that for the West Coast, we have it in Saldanha, and for the East region, we have it in, we try and have it in George, which is probably the best place to do it. Member Dagmar, so your mic is unmuted. No, muted again. Okay, I would recommend that we have it in Saldanha Bay and George. Are there any further recommendations or comments on that?
Chair, sorry. You know, I sometimes find that, you know, if you're trying to involve, you know, the Overberg and the Boerland and the West Coast, that sometimes Worcester is kind of a more central venue, or, you know, like somewhere along the N7, like Moreesburg, because I just find that Saldanha, you know, it's actually, you know, on very kind of, let's call it the west side of the West Coast, you know. So I don't want to go, I think at the end of the day, let's leave the discretion up to you. But one scenario would be, you know, George and then Worcester to cover everything else, you know, West Coast, Boerland and Overberg, and then George covers the whole eastern section. But I think we should leave it to you. I think we've agreed on 2 outside the metro and 1 in the metro, but I think let's just leave it to you and not have a whole debate here. But it's just a view, yeah.
Thank you, Member Dagmar. I will take that into consideration. I appreciate that input. Members, if there's no further input, we will then draft the media plan and the media link to the website, which will have all the necessary info that the public needs to make viable comments to this bill. If there are no further deliberations on point number 3 of the agenda, I would like to move to the consideration and adoption of the draft committee minutes of the 9th of June 2023. Ms. Commissioner Ahmed, if you can flight those minutes for us, please. Ms. Commissioner Ahmed?
Yeah, Chair, I'm pressing share. Just give me a moment. Oh gosh, hold on. Okay, is it showing?
It's showing now. If you make it a little bit bigger.
Okay.
That's page 1. And we go to page 2.
Mm-hmm.
Thank you very much. Member Dugmore, as you were the only other person present as per the minutes, would you like to move the adoption of the minutes, sir?
Sorry, Chair, I just want to just quickly check the resolutions.
Yeah.
Yeah. No, that's fine. I've got no problem to second the adoption of the minutes. Thanks, Chair.
Thank you very much, and the minutes are so adopted. Thank you very much, Mr. Odendaal, for your input. You're welcome to leave the meeting while we do the resolutions and the actions, and all the other members of the administration. You're welcome to leave the meeting while we do the resolutions and the actions emanating from this meeting. Thank you.
Thank you.
Members, we now move to resolutions and actions. Are there any resolutions or actions that you'd like to highlight at this time?
Chairperson, I think your outline with regard to your recommendations with regard to the process ahead for the public hearings and that sort of thing, I think we must make that a resolution. Thank you.
Thank you very much, Member Plato. Are there any other resolutions? I have received recommendations from Member Bosman, and I will take that into consideration. It's regarding the public participation phase of the bill we spoke about today. Members, if there are no further recommendations or resolutions, I'd like to thank you for your attendance at short notice. As we all know, this bill is urgent and is important. So I'd like to thank you for your cooperation in accepting this meeting, and I would wish you well. And let's hope that our netball team makes us proud, which I'm sure they will later this afternoon. Thank you very much, everybody. This meeting is adjourned.
Thank you, Chair and members.
Thank you, Chair, everybody.